Hello everyone and welcome to today's webinar. I'm Padma and I'm a Senior Associate here at Irwin Mitchell and I head up the Manchester employment offering here at the firm. I'm also joined by Glenn Hayes, who is our Northern Head of Employment. And I'd also like to do a quick shout out to We Are Adam, who have partnered with us today. And so thank you for your support and welcome to those of you who are joining through We Are Adam. I think this has probably proved to be one of our more popular events. We are running this nationally and I think we've had over 1,000 people subscribe to this. And I think it goes to show the difficult times that we're all working in, and it feels as if we've been going through it for quite some time now. And for those of you in HR, you're probably seeing more within the last couple of months than you do in an entire year. So what Glenn and I are going to do today is go through some of the key questions that are coming through in relation to the furlough scheme and the types of issues that we're seeing in relation to businesses starting to reopen and asking people to return to work and what the next few months will look like. So the session will be for an hour. There will be some time at the end for questions and answers. So on the webinar feed that you should be able to ask questions, so please do. Glenn and I ran this on Tuesday and as you can imagine we were inundated with questions, so if you can perhaps put your name as well when you're asking the question, only we can see that it's you asking the question, but that will allow us that if we can't answer it during today's session, we will give you a call back at the end and go through those questions with you, but please do use the question functionality that's on there. We will also send out the recording after this is done, so that if you've got colleagues that wanted to join couldn't, then by all means you can pass on the recording. And finally from me, before I hand over to Glenn, your feedback is really important to us. This has been put on as a result of feedback from clients of things they want to hear, and we want to make sure that we are running relevant webinars for you. So towards the end, there'll be a feedback link that pops up. So again, if I can urge you to fill that out, that would be great. So without further ado, I'm going to hand over to Glenn to kickstart this morning's webinar.
Thanks, Padma. So I'm gonna look at the sort of timeline then that we've had so far, because obviously, as everybody will know, on the 23rd of March, probably a day locked into our heads now, that we got put into national lockdown and many businesses had to close their doors. Now, the government's never actually ordered non-essential work to stop, and indeed it's actually encouraged it to continue. But there are obviously some businesses that were closed by law, so hospitality and shops, etc. And the government's now said that other sectors can open from July, and that might include hairdressers. So hopefully I don't have to get any more COVID cuts. But it also, that depends on whether things are safe, essentially, and that's by reference to the government's 5 main tests. Obviously, restaurants and pubs are likely to be the last of the sectors to open, albeit the date that's suggested for those seems to be July. Dentists are now open, and in particular for me, the 1st of June was a key date because I could pack off my 1-year-old and 3-year-old to nursery, and certainly that's been an issue for many people. To give you an example, I was doing a tribunal by video link, and my 3-year-old ran behind a curtain completely naked and hid behind it, which the judge took pretty well. And hopefully today, with them being at nursery, my wife's in the other room, so assuming she behaves herself, we're all okay. Organisations have got to contend with the reintroduction of local lockdowns if the RA continues, but we're effectively now being encouraged to go back to work if it's safe to do so, and people can't work from home. The position still remains, however, though, if you can work from home, you should do so. If we can move the slide on, Pam, that would be great. Okay, so in order to safely return to work, then what do businesses have to do? Well, essentially, businesses obviously need to plan on how to open safely, and most employees need to work, but only if they can do so safely. So no business should reopen unless they are what is termed COVID secure, which is the new buzzword that's been introduced. What does that actually mean then? Well, what it means is that you've got a duty as an employer to take all reasonable steps to ensure that your staff work in a safe environment. But also, critically, if you identify risks, you've got to take steps to reduce those risks to the lowest practicable level. So you're not required under law to eliminate those risks altogether. You're just required to take steps to reduce them to that lowest practicable level. Now, there's various guidance in relation to this that's available. So the minimum steps that you must take according to the HSE risk assessment guidance is that you are to identify what work activity or situations might cause transmission of the virus, to think about who could be at risk, decide how likely it is that somebody could be exposed, and then take steps or act to remove the activity or situation, or if that isn't possible, control the risk. Now, the government have also produced some guidance, and there's a lot of similarity between the two guides, as you probably expect. But the basic rules that the government have put forward is that if you can maintain social distancing, you should do so. But if that's not possible, you can only reopen if you put in place suitable measures to control the risk of transmission. So that might include, for example, putting barriers in shared spaces, creating shift patterns so the same workers work together, and staggering shifts so there's less people within the workplace at any one time, working with the landlord and other tenants to identify and minimise the risk. But remember that even if you provide all the equipment and issue the instructions to your staff, if you don't ensure that those instructions are then followed, then again, you may well be in breach as an employer. So a good example to follow would be the supermarkets, I suppose. So they've obviously led the way because they've remained open to the public throughout the pandemic. So they've got barriers at the tills, one-way systems, limit the amount of people that can come in, and limit the amount of people who can shop together, for example. So the government guidance, though, still remains that employers should take all reasonable steps to allow employees to work from home. So that is the starting point. And obviously, when the government introduced the guidance, obviously 5 o'clock, 5:30 on a Friday night, as per all the employment law guidance, which is a source of much angst for every employment lawyer and HR professional, I'm sure. But it produced them for the various different sectors, and it is worth a read, in my view, depending on which sector you fall into of your respective guidance note. There's a huge degree of overlap between them, in fairness, but it is worth reading. One thing the government did say in their guidance, though, is that employers shouldn't have to provide PPE as a precautionary measure against COVID-19, and it's only necessary to do so if you usually supply it to your staff, or if they're working in clinical settings like a hospital, for example. So one of the big issues that a lot of employers were facing was to whether or not to provide face masks, and clearly they don't need to do that unless you're in that clinical setting now. The government argue that social distancing, providing proper facilities for hand washing, regular cleaning and managing staff to minimise contact are much better ways of controlling the infection risk than PPE equipment. Just remember, though, if you do provide it, okay, your risk assessment's got to determine whether it's necessary, and if so, what type of or grade you need. And if you do provide it, you can't charge the staff for it, and it has to fit them. So if you're going to reopen, then things like putting proper facilities in place for hand washing or antibacterial wash, opening the barriers so that people aren't crushing through them, use of one-way systems are all much better ways of seeking to control the infection. Okay, can we move it on, pardon, please? So in terms of the risk assessments then and consultation, there's two sets of general regulations that might apply here. I just wanted to touch on them for you. And what they're designed to do is to enable you to develop, maintain and promote measures that ensure health and safety at work, and also to check how effective those measures are. So the two sets of regulations I've set out for you on the slide, and the critical thing is that if you recognise a union and you've agreed to collectively consult a union health and safety representative, you have to discuss your proposals to make the workplace safe for the staff to return to with that union. Okay, now if you don't have a union representative, then you need to consult your employees directly as individuals or through workforce elected health and safety representatives. And if you're not sure, then it's best to take advice. Now, to me, the people that we've seen do this best, and this consultation about returning to work, are those that are actively engaging in dialogue with their staff. So it's not just lip service. Okay, consultation involves giving information and taking into account what your employees say before making any health and safety decisions. So the law doesn't state when you've got to consult or for how long, but it does state you've got to consult in good time before you reopen. And in practice, what that means is that you have to allow your employees time to consider the issues and provide their responses and provide them with informed responses to those points that they're making. So the employers that I've seen do this the best include things like sending out questionnaires to their employees in advance of a return, saying, how comfortable do you feel about returning on a scale of 1 to 10? Is there anything that causes you particular anxiety about a return? Is there any suggestions that you can make to alleviate to that? This is what we are planning to do. Is there any issues at home that prevent you from returning, for example, childcare, which is a big issue? And it's critical that you engage with your employees and take their views on board. But ultimately, consultation doesn't remove your right to manage, and it is you as the employer that's responsible for making the final decision. But if you recognise a union and they don't agree that it's safe for workers to return to work, just remember that they can ballot the members and take strike action if sufficient numbers vote in favour. And we've seen that type of issue being threatened, certainly in the education sector, where the unions are effectively, we've heard some horror stories where the unions have effectively said, well, to staff, don't actually engage with your employer as to your concerns or not, because if you don't do that, they won't be able to reopen, which to me seems slightly odd, to put it mildly. But if you don't comply with the regulations, remember you'll be committing an offence. So there's health and safety inspectors from HSE and local authorities that can enforce the regulations where there's no evidence of consultation. And it's critical that you do engage with your staff in that regard. Pamela, can you just push the slide back a second? Now, one of the questions that was asked to us was this point about publishing the assessment on the website. So the government guidance says that they would encourage all employers to publish their risk assessments on the website, but they would expect large employers, by which they mean people who employ over 50 people, to publish their assessment on the website. Now, at the last session that we did, it was pointed out to us that was there any requirements as to where an individual employer needs to publish that, and then somebody pointed out that Irwin Mitchell's wasn't on the front page, for example. And I don't think there is any guidance really on that point. I think there is an expectation that you should do so if you've got over 50 people. And there doesn't appear to be a sanction for not doing so at the current stage anyway, albeit the guidance is evolving all the time. And I think it's important that you at least have some form of link to it on the front page of your website, or some signpost as to where it can be found for the outside world to view. You can move it back now, Padma. And one of the issues that has taken somewhat centre stage as well, particularly in certain parts of the country, such as London, is the issue about travel to work. We've probably all seen the pictures of crowded buses and tubes, and it's clear that social distancing is impossible for many people who rely upon public transport to get to work. Now, obviously, Boris Johnson said that ideally it would be better if people cycle to work or walk to work, but I suppose it depends on how long your commute is. And there's 4 key legal responsibilities that come into play here, really. One is health and safety legislation. The second is the issue of the common law duty of care, and that's to take reasonable care for the health and safety of your employees. And if the employee suffers harm which is caused or materially caused by the employer's acts or omissions, and that harm was reasonably foreseeable, and it's fair and just to impose liability on the employer, then that liability can be imposed. There's also a duty of trust and confidence, so if that's breached, then employees can claim constructive unfair dismissal. And there's also a duty not to subject employees to a detriment or dismiss them for taking evasive action over serious and imminent danger, something that Padma is going to touch on a bit later on in the talk. So what does that actually mean, though, for your employees travelling to work? Well, the health and safety guidance on it's really limited, and effectively what it says is that it asks employers to identify where people can travel alone in their own transport and to maintain social distancing. And the government guidance says employers should think about how their employees should travel to work. It doesn't go any further than that. But what it does, what the guidance does suggest though, is that there are some practical steps that could be taken which would help employees to maintain social distancing while travelling to work. So obviously travelling to work alone or cycling would be the best example, but also employers staggering arrival and departure times is a critical issue, so that people can keep to the 2 metre social distancing rules by not using the entry exit points at the same time. So if you can avoid the rush hour traffic, for example, if there is such a thing now, or at the minute at least, then that will be helpful. And also to provide hand washing facilities at the entry and exit points, so running water and soap and paper towels or hand sanitizer, so that people can wash their hands when they get to work and leave the work. So that's some fairly basic things that can be done. But my view is that they've got to do a bit more than this, in fairness. So if you as an employer know that your employees need to use public transport and it might be overcrowded, then clearly that increases the risks that staff will become infected and in turn possibly infect other members of staff. So there's now a travel guidance document for passengers to consider all other forms of transport before using public transport. But where there is no alternative, then people should try and travel, you know, for example, wait for another bus or train if theirs is already full, travel off peak, wear a face covering, avoid eating and drinking whilst travelling. So in my view, you as an employer need to find out how your staff are going to travel to work and if they've got any particular concerns. Only ask those who are willing and able to attend the workplace to do so if it's possible. Assess each individual employee's situation individually, because some might be around the corner from work, some might be 50 miles away, and their general health. And if you can, try and support other ways for them to get back into work. So if there's parking available that can be freed up, for example, if you stagger the start and finish times, or you can subsidise that parking, then again, that would be something that would be really useful. Now, on these risk assessments, you need to also identify those categories of workers that might be particularly vulnerable. So vulnerable people who are not required to shield may be able to return. Those who are shielding may not. So the guidance has changed this week. So my brother unfortunately has got terminal cancer, but so he's been told that if he leaves his house and therefore requires a ventilator because of the type of cancer he's got, he won't be given use of a ventilator because effectively it's needed for people who are not as serious as him. So clearly it would be it's impractical for him to leave the house. But also consider other people, so pregnant women, you know, they've got special rights, including the right to be suspended on full pay if the workplace isn't safe and no other work can be given. So they've got first dibs on the safest work. And also there's been a lot of information about the issue of BAME staff. The report that was leaked this week or has come out now with increasing evidence that COVID-19 adversely affects that element of the population. So you will need to assess the risk, particularly in relation to those types of individual. So just wanting to touch on, if you just move it on, Padma, the situation about what the future really holds then. So unless you're in the fortunate position of being able to pick up where you left off, then you're likely to need to use a number of different mechanisms to reduce the payroll costs while you assess what your organisation is likely to look like over the next few weeks and months. So if you're not going to need as many people as before, then there are a number of options available for you. I'm just going to touch on a few of them now, the sorts of things that we're seeing really. So there's obviously the continued use of the furlough scheme, and I'm going to talk a little bit more about that in a second. There may be changes to people's terms and conditions, either permanently or temporarily. So pay cuts, for example, 9-day fortnights, you know, other freezes of certain benefits or pension payments. Might be redundancies, or there might be other such things like unpaid leave or sabbaticals that people can take advantage of, or requiring people to take holiday whilst people are less busy in order to reduce that liability. Now, the first one I wanted to talk about really was furlough, because there was an announcement made again on a Friday at the 29th of May, again 5:30 on a Friday night, in relation to the furlough scheme. So if you remember, initially the furlough scheme ran from the 1st of March to the end of June. It's now been extended to the 31st of October, and the current rules will continue to apply until the 30th of June, which is a month earlier than indicated. But from the 1st of July until the 31st of October, there's going to be more flexibility under the flexible furlough scheme. So the details that we've got so far in relation to this is that a furloughed employee will be able to return to work and still be eligible to remain on the scheme if they can't return to their pre-furloughed hours, because, for example, there's not enough work to do. And it gives you a great option of reintroducing staff to work. But again, just remember that employees have to agree to this as before. And but under the new scheme, you as an employer will have to pay towards their furloughed pay. So the scheme is closed to new entrants from the 30th of June. And from that point onwards, employers will only be able to furlough employees that have been furloughed for a full week, 3-week period prior to the 30th of June. So what that means is the final date by which an employer can actually furlough an employee for the first time will be the 10th of June, in order for the current 3-week furlough period to be completed by the 30th of June. Okay, so what that appears to suggest, okay, is that if you have a member of staff that has been on furlough and has been returned to work, okay, then ultimately they don't necessarily have to be on the furlough scheme as at the 30th of June. They can have returned to work and then be re-furloughed after that point. Okay, so it's not 100% clear, but the reason I'm suggesting that that is the case is that the guidance that came out, and there's further guidance due on again Friday, the 12th of June, is that it's closed to new entrants. So that suggests to me that ultimately, if you've already been on the scheme or you are being rotated, for example, if you're not currently on the furlough scheme at the 30th of June, it doesn't prevent you, in my view, unless it's clarified differently on the 12th, from being re-furloughed after that point. Okay. Now, what does it mean, the flexible furlough scheme? Well, what it means is that employers will have to make a modest contribution towards the cost of furlough. So I've set out on the slide there that from the 1st of August, the government will continue to pay the 80%, subject to the £2.5 cap. But unlike previously, the employers now will have to meet the cost of the employer's NI and pension contributions. If you remember beforehand, those NI contributions, and at least a part of those pension contributions, so the minimum auto enrolment part, was paid for by the government. So from the 1st of September, the government will pay 70%, subject to that reduced cap, and employers will have to contribute 10% of that cost. And then from the 1st of October, the government will pay 60%, and employers will have to contribute 20% of that cost. So key things for you really to consider as an employer is, can you afford to top up? Okay, and if so, for how long? The guidance doesn't suggest, for example, that if you can't afford your 10%, that you can claim the 70% from the government. It seems to suggest that you would have to contribute the 10% in order to get the 70. Okay, and if you can't contribute to all of it to gain the benefit of the CJRS, then you might have to agree something else with the employee. So are you going to need to make redundancies? And if so, are you going to wait to do that? Or are you going to start the process beforehand? Padma is going to talk about redundancy in a bit more detail. And just a note on affordability, really, a quarter of the company directors surveyed by the Institute of Directors say they won't even be able to pay the 20% of the furlough scheme if they're asked, as well as having to pay national insurance contributions, which is an additional 5% on top. So I think that causes potential real issues, as good as that scheme and its intentions are. I'm going to pass over now to Padma, who's then going to deal with it all, the next part on consultation and staff returning safely to work.
Okay, thank you, Glenn. So I'm going to, as Glenn said, look at staff returning back to work, and the question that we're being asked at the moment is, all around, what notice do we have to give? And from that perspective, unless your letter putting or agreeing the furlough leave with the individual has a specific timescale on there, it's what's reasonable. And my view is to do it as soon as you know that you are going to, you've got a date in mind of when you want to start reopening. And that's because you've got to think practically there's a lot to do there in terms of making sure that you've got your risk assessments in place and that you've communicated and shared those with staff to understand what their concerns are. And if you have people that come forward saying, I feel that I'm in a vulnerable category, or I'm shielding, or someone else in my home is shielding, it gives you that time to take the pragmatic approach, look at other alternatives, and address individual concerns well in advance of the date that you're wanting to open up an office or a shop or something of that nature. Also, Glenn mentioned schools going back, but we've got to remember that it's only certain year groups that have gone back, and parents aren't obliged to send their children back either. So they may have children with asthma or other medical conditions, or have just simply chosen not to have their child go back to school or nursery. So don't always assume that people have childcare in place as well. So have that open dialogue with staff in relation to that. The other point is that for people on furlough were allowed to get, or are allowed to get, other jobs that aren't for their employer or associated employer. So again, people may have done that, so they may need to give notice to their other employer in relation to the job that they've taken on. So it's all about reasonable notice, and we have been helping a lot of clients in relation to drafting those letters with the right tone and feel for that organisation to get as much engagement as they can from staff. So do get in touch if you need any support in that regard. So going on to the next slide then. People are obviously genuinely fearful in relation to coming back to work, and a lot of questions that we received this week centre around people saying, well, I'm scared for my children, my family, etc. And there's that psychological fear of coming back to work, travelling, especially because the death rates in the UK are still quite high. And there's a lot of evidence of people not sticking to social distancing rules. So we've seen pictures of people on beaches and all those types of things. So we've got this big fear as well in terms of a second wave of the pandemic starting. So if you are in that situation where people are raising concerns about returning back to work, it's all about dialogue again, of speaking to staff. Why is it that they're concerned? Addressing those concerns. One particular challenge is if you've allowed people to work from home up until now and they've not been furloughed, why is it that you're suddenly asking them to come back into the workplace? Talking people through your risk assessments and what you've done and what you are doing. And remember, people that fall into the vulnerable category might also or are highly likely to fall within the definition of being disabled for the Equality Act. And so there may be an obligation from an Equality Act point of view to make reasonable adjustments. So think about those obligations and whether actually, if people are raising concerns, they are vulnerable, what other options are open? Can you tweak their role so they're in doing something where they are less exposed than other people might be that are not considered to be as vulnerable? Are there other tweaks? Are there things that you can agree with them, such as taking holidays or sabbaticals, unpaid leave, all those types of things that Glenn has mentioned. But it is something that needs careful planning and thought as you are going through. So moving on to the next slide then. Glenn mentioned health and safety legislation and the fact that it's been there for years and years, but none of us have really had to go into the level of detail as we have done right now. And in the Employment Rights Act, there are specific provisions in there that allow individuals to make a claim if they're subjected to a detriment, such as being suspended or having their pay cut, or being dismissed in circumstances where they believe that there is a health and safety risk. As I said, it's not highly litigated at the moment, but it is something that I suspect we're going to see a lot more of, because we're already seeing unions kick up a fuss, citing legislation to say, if you are going to force our members to go back to work, do you realise that there are these claims that could be bought? And in terms of when this particular right kicks in, as it says on the slides, it's when there is circumstances of dangers where someone believes that there is serious and imminent threats as an employee to their health and safety. And that is where they might have left their place of work, refused to attend a place of work, or is taking appropriate steps to protect themselves or other people. And that other people definition is actually quite wide. So it can include family members, their colleagues, the wider public, and so on. So that threshold to meet that test is quite low as an employee. So do keep a watching eye in relation to this, because even if you have put in measures at the start of someone coming back to work, you've got to have people adhering to them as well. So it might be enough to give comfort to get people back, but if people aren't then adhering to them, these rights could potentially kick in. So do keep an eye on that. If someone says that their rights have been breached in relation to this, then a claim would be for an automatic unfair dismissal, which people don't need any qualifying service, so they don't need the 2 years protection as you'd normally see for unfair dismissals, and the compensation is uncapped. And even if you're not dismissing someone as a result of raising these concerns or spuriously making them redundant from employees' eyes, an individual can resign and claim constructive dismissal, again with the same rights of uncapped pay. So it's not only broad in its covering, it can be quite costly as well if you get it wrong. So moving on to the next slide, please. Looking at what this means in a bit more detail, there needs to be actual danger, and that is an objective test that is looked at reasonably, which, as I say, you can mitigate the risks of meeting that test by informing staff carefully and consulting with them as to what changes you're putting in place, how you're looking at protecting their well-being, and seeking their feedback as well and taking that on board. And in terms of there being actual danger, clearly, I think it is right for people to assert that they think there is a danger, because there is a lot of medical evidence out there, as well as the various medical groups disagreeing as to what the level of danger is and disagreeing on the speed of return to work and so on. So again, it's a moving beast that you need to keep your eye on as to actual danger. And as time goes on and as numbers decrease, actual danger definition is less likely to be met. But at the moment, I still think that there is an opportunity, or it is likely for people and reasonable for them to cite that there might be an actual danger there. Not only does there have to be a danger, but then the individual needs to reasonably believe that there is a serious and imminence of that danger. And again, that is something where you can deal with that with open dialogue with your staff, looking at what their concerns are and what you potentially could do to address those, to then be able to say to a tribunal, well, I don't think that belief is actually reasonable anymore, because this is what we've done and we've communicated with the individual, so they have the knowledge and the right information in place to make that informed decision. And so this is something that I think as organisations need to look at as a case-by-case basis, and just something to be aware of if someone is raising concerns and maybe taking legal advice, because as I say, it's not really a litigated area of law at the moment, but something that we will see a lot more of. And the thresholds to meet the definitions are quite low for an employee, so just be careful of that. So moving on to the next slide, Glenn mentioned the furlough pot and various changes that we're going to see over the next coming months. And as part of that, something that we are already seeing is employers looking at and planning changes to terms and conditions, whether that be to do with hours, pay, and those types of different things. And your starting point, if you're wanting to look at something like that, is a contract of employment. And think about what is the change that you're wanting to make. For example, is it pay? And if it is that, does the contract specifically allow you and expressly allow you to make changes in relation to that specific topic? So in this case, pay. And is that wording clear and unambiguous? Because if there is any ambiguous wording there, there is a legal principle that allows an employer to construe that wording against the drafter. So in this case, being the employer who drafted the contract. So it needs to be very clear and specific to the topic and the change that you're wanting to make. And when looking at that clause, see whether it requires you to follow a certain process or give certain notice as well. Because with all of it, you've also got to act reasonably. So if it is quite a broad wording that allows you to make that change, you can't then just go and exercise it as you wish. So for example, if there is a right to change hours or pay, it doesn't mean that you can then make a 70% cut without proper consultation. The other thing to point out here is a lot of employers within their contracts tend to have a general flexibility clause that allow for minor changes to the employment relationship as business develops, as the relationship develops and so on. That isn't going to be enough to change things like pay and hours that go to the heart of the contract. So if you're unsure, again, take some advice, but do look at the contract as your starting point. Risk to the business of getting this wrong in terms of exercising the clause unreasonably or exercising an unambiguous or very wide clause is that individuals can bring a breach of contract claim, a constructive dismissal claim, which in this set of circumstances they'd need 2 years service, unless they're arguing that it's to do with an element of discrimination as to why they've been picked for that change. But do also, talking on the topic of discrimination, think about whether the change that you're making could lead to an indirect discrimination claim. And so what I mean by that is, does the change disproportionately impact a group of employees with certain characteristics? And the best example I can think of there is changing working hours. So Glenn talked about staggering people coming into the workplace, and traditionally you find women with children contending that actually changing working hours can have an impact on their ability to get to work, given that they might have to do child drop-offs, nursery drop-offs and so on. Moving on to the next slide, if you don't have the contractual right, then what you'd have to look at is consulting with the individuals. And I can see some questions coming in relation to that, and do carry on using the question functionality for these things if you want me to go into any further detail on any of these topics. If there's no contractual right, as I say, consulting with staff and any recognised trade unions that are there for the purposes of consulting with staff and the employer in relation to the change that you're wanting to make. So if you have a collective agreement, go back to that and see what the union or works council is authorised to consult with you about. ACAS has produced some guidance in relation to this as well, which if you've not read it, I do think is worth taking a look at because it gives some useful tips and guidance as well. And it reminds employers that it is a two-way process, so that is by nature of what a consultation is. And to effectively and pragmatically get that change through, it's all about explaining the reason for the change and then talking to employees, understanding their concerns, addressing them and looking at their ideas for alternative suggestions as well. So one thing that I had right at the beginning of this process is an employer looking at making pay cuts. And a lot of the employees came back and said, well, actually, we'd rather that you cut the contribution that went into our pension pot, so the hit is not as immediate to us as an individual. So do think about those things and make sure that you understand those alternatives, because a lot of times when you see claims coming through, it tends to be because people don't feel heard, or that they haven't been given that fair opportunity to understand and give their points of view across during the process. If changes are agreed, you need to make sure that you record that in either a variation letter or a contract of employment. And for those of you that joined us earlier in the year for our update seminar, you'll be aware that from April 2020, employers issuing any new contracts need to make sure that they are post-April compliant, and that means that more information than we've been traditionally used to including in contracts need to now be included. So just be aware of that. And for those of you signed up today that have our IMHR Plus retainer, that is covered as part of your retainer. So just get in touch with your relevant dedicated lawyer in relation to that. If the changes can't be agreed, however, you need to do what is known as dismissal and re-engagement. And so what that means is you immediately dismiss the individual with notice and after consultation on their current contract, and issue them with a new contract and offer to take them back on the new terms that you've been trying to negotiate with them. In reality, this really should be your last resort, because by virtue of dismissing someone, you are going to expose the business to an unfair dismissal risk, and having to show a tribunal that you followed a fair process and that it was reasonable for you to dismiss. So it is important that you get that process right. So as I say, if you are considering this option, given that you are going to have an unfair dismissal risk, the types of things you need to be thinking about are: have you done everything you can to reach agreement? Are the changes absolutely necessary to fall within that potentially fair reason for some other substantial reason, as we've set out on the slide? Think about the whole risk to employee engagement and morale and what that's going to do with it in the long term. Follow a fair dismissal process, so that's giving the right to be accompanied, giving the rights to appeal, and so on. And also, just again, going back to communication and the tone, that is going to be really important, because if you get that right, hopefully most of your employees will understand the reason for the change and will be on board with that, and they would rather keep their job, albeit with a pay cut, change of hours, whatever it may be, rather than face redundancy and finding a new job in this current economic climate. So again, as I say, do take some advice in terms of the communication if needed. Moving on to the next slide, in cases where you're looking at either making redundant or making changes to terms and conditions, where it involves 20 or more people within a 90-day period, there's going to be obligations to collectively consult. And as Glenn mentioned, the IOD lobby group has effectively already said a quarter of people surveyed have already said we're going to look at making redundancies either partway through the furlough scheme or towards the end. And so partway through would be when they have to start contributing. And collective consultation means that where you are affecting those dismissals, and so redundant in this sense has a wider definition and includes not just redundancies in the traditional sense that you see, but also dismissals where it's anything not related to the individual themselves, where they've not committed an act of misconduct or something of that nature. So dismissal and re-engagement would fall within this. And it requires you to consult with staff for a minimum of 45 days, minimum of 30 days, sorry, up to 45 days if you're looking at dismissing 100 or more within a 90-day period. So something that you need to start bearing in mind now, given the process that you're going to have to follow, which we'll come on to in a second. But you need to think of it from the start, because at the start of a dismissal and re-engagement process, you won't know how many people and what percentage of that workforce are likely to agree to that change. So you may be falling into this category, and you need to think about what you're going to do to comply with those legislation requirements. And the reason why it's important is that if you fail to properly consult, the compensation for a claim in relation to this is on top of any unfair dismissal award, notice pay, redundancy pay, is a protective award of up to 90 days uncapped pay per affected individual, as well as a criminal sanction for not properly notifying the Secretary of State and following that process that's required there as well. So the penalties can be high, so do pay some attention to the obligations to collectively consult if you think you're going to fall within that category. So moving on to the next slide, consultation under collective consultation processes can only begin once you have the elected representatives in place. So think about whether you've already got a works council or trade union body that covers the types of changes that you're wanting to make. Just because you've got a trade union representation within the workforce, don't fall into the trap of thinking that it covers everyone within the workforce, so double check that it does, and also that your agreement covers the type of change that you're wanting to make and not something else. If you have that in place already, then great, you're good to go from a consultation point of view. If not, you need to think about how you're going to elect representatives, how many representatives you need per department or work group or location, and what they're going to be representing about. And to elect those representatives, again, you need to think about the process, because usually you'd have a ballot in the workplace and you do communications through work email systems. So you're going to have some troubles or difficulties in doing that if people are at home, furloughed or on unpaid leave. And so factor that in, because that's going to take you longer to get this process going, and your normal communication rhythms will be affected as well. And also think about it from a GDPR perspective, because you might want to think about using things like WhatsApp, Microsoft Teams and those types of mechanisms to communicate with staff. But traditionally, and as a requirement of the legislation, representatives need to have access to the people that they're representing to filter that information down and also take the information from them to feed back to the employer. So from a GDPR perspective, how are you going to get the personal email addresses to people and give them the platform to be able to consult with staff as well? Think about whether you're a type of organisation that would prefer one long letter and the individuals prefer all the information in one go, so they feel what the start and end goal is and know about that, or is it better in bite-sized pieces? And I've also seen clients do videos for these sorts of communications, which I think is great from a personal touch point of view, but also getting the message across, because I think one difficulty that you can have with letters is that the tone can be read differently by different people. And so think about the different options that are open to you there. But as I say, it's something to start thinking about now, because if you think about how long it's going to take you, if you're the type of organisation that's going to have to make changes come August, when you have to start contributing towards a furlough pot, starting the process now is probably going to get you ready in time for August, when you're going to have the obligations kick in. So do think about that. On the bottom of the slide, we have mentioned special circumstances defence, and what that is an acknowledgement that you should have complied with legislation, but whatever has happened has meant that you don't have enough time to comply with all of your obligations, and it allows the tribunal to look at whether or not you should be awarded, or an individual should be awarded, a 90-day uncapped pay. Traditionally, tribunals don't really like it as a defence, and it tends to be a high threshold to meet the definitions to be able to fall within that special circumstances defence. And I think there's been a lot of commentary and question as to whether COVID would fall within that definition of being able to rely on the special circumstances defence. I think at the beginning, potentially, but now that the furlough pot has been put into place, it does offer a breathing space. So I do think that for the majority of people and companies, a special circumstances defence possibly won't work. There will be the odd exception. So again, do stay in dialogue with your representatives or your solicitors in relation to that, to explore that if you think you fall within that category. But I do think that for the majority, the furlough pot has given that breathing space to fall within that. So do think about the benefits of speed outweighing the risks of a claim. Moving on to the next slide, a quick mention that one concern has been whether employee representatives who have been furloughed, can they act as representatives and can we undertake a consultation process? And the guidance is very clear on that is fine, that will not breach the furlough rules to do that, so you can use that. Moving on to the next slide, if changes to terms and conditions isn't enough and you still have to look at redundancies, the usual principles in terms of redundancy, the process you follow, the consultation, all that sort of stuff, nothing has changed in relation to that, and you carry on following that process. The only thing that I wanted to mention with this slide is in relation to timing, because in a redundancy process, you are obliged to look at suitable alternatives to that redundancy situation. And in my view, the government retention scheme, so the furlough pot, does give you that breathing space to avoid redundancies. So I do think you need to look at that as a potential alternative and be able to explain as to why that isn't enough for you to delay or keep an eye on whether you need to make that redundancy, because as I say, it is a suitable alternative. That doesn't mean that you can't make redundancies now, because we do have clients who say, well, despite the furlough pot, we've got crippling pension costs and we know that business isn't going to resume to the same level, so we need to start it now. Or as Glenn says, you've got businesses that from August are going to be able to even contribute the minimum in terms of national minimum, not national minimum wage, sorry, the national insurance contributions. So again, you may need to start kick-starting your redundancy process. Moving on to the next slide then. As I say, furlough is all about preserving jobs. In terms of notice period then, if you have to make a redundancy, again, the usual principles apply. So you go to the contract or give the statutory minimum, whichever is the greater in terms of notice if you're looking at dismissal. And there is some conflicting views out there as to what you pay during the notice period if someone is furloughed. There's some commentary saying that notice period is similar to holiday pay, and we know that the government guidance is if people take holiday, you can use the furlough pot, but you need to top it up to 100%. So in this case, the safest option would be to use the government retention scheme to pay 80% of the notice period, and then you top up the rest. However, in some exceptional circumstances, there are quirks in the Employment Rights Act, depending upon the type of contract, where you might be able to pay notice based on the redundancy, the reduced furlough pot. So do take guidance, because that will require some review of the type of contract that you have in place if you are considering that. Going on to the next slide, can you use the redundancy, can you use the government furlough pot, however, for redundancy pay? And the answer to that is no. The government guidance is clear in relation to that. So whilst you can use it for notice, any redundancy pay will be the employer's liability, and they will need to foot that cost themselves. And again, there's a bit of a differing commentary in terms of whether you can base it on furlough pot, reduced salary, or someone's pre-furlough salary. And again, that will depend upon the contract. So where you've got contracts without specific working hours, for example, you might be able to pay based on reduced furlough pay, but the safest option again would be to pay on the pre-furlough pot. So I appreciate that was quick canter 3, but I wanted to ensure that we had a little bit of time for questions, and I know we've had some come through. As I say, there is a feedback link as well, so please do complete that, and we can make sure that we are making sure that these are tailored to the types of things that you want. But before we do wrap up, Glenn, have we had some further questions come through that we've not answered as we've gone through?
Yeah, we have. Let me try and deal with them as best I can then. So the first question is, if you refurlough somebody before the 1st of July, can it be for less than 3 weeks? Well, the answer to that is yes, it can, but no, you can't if you want to claim under the government retention scheme. So obviously there's still a minimum requirement of a furlough of 3 weeks minimum to reclaim under the CJRS. So if your question relates to the ability to reclaim, the answer is no. The reason for that 3 weeks is that the last date is the 10th of June, so that people can be furloughed for 3 weeks in order to reclaim under the scheme, essentially. So that's that one. BAME staff for our Black, Asian, ethnic minority. So that's what the report was about in relation to this week. So it's Black, Asian, minority, ethnic. So the next question was in relation to staff who are encouraged not to engage in conversations regarding safety fears. As per my education example, what recourse do employers have? Well, my view is that employers have got to make decisions based on the information that they've got. Okay, so if members of staff refuse to engage in conversations at all, the first port of call will be to go back to them and say to people, well, look, we will have to base our decisions based on the information that we've got, rather than what the input we would like to have from you, and it will be useful to do that if possible. And if staff are refusing to come back to work, and you can explain there is a safe place for them to return back to, in your view, then in my view you don't have to keep them on furlough. You can effectively place them on unpaid leave. If they are incapable of returning to work, then obviously the ultimate decision could be to terminate their employment on the grounds of capability. But it's really trying to get into a dialogue with your members of staff and seeing whether you can reduce those fears. Somebody's asked us about the risk of criminal prosecution in the worst case scenario if an employee contracts COVID in the workforce and becomes disabled or dies as a result. It's a really interesting question, that I think, because anecdotally what I've heard is that the insurers are saying to people, well, we will not cover this type of situation if somebody dies on your watch, so to speak. Now, I'm not a personal injury lawyer. There are plenty of people in this firm that are, but I'm not. But my view would be that if you've taken all reasonable steps to reduce that risk, then you stand in a pretty good chance of being able to defend a criminal prosecution. Obviously, if you introduce rules and then turn a blind eye to their adherence, the same way as any other health and safety issue, then the position could be somewhat different.
I think as well, there needs to be a causal link as well, doesn't there? In that, someone's got to prove that they got it whilst at work and not whilst shopping, for example. And so, yeah, it's all about that reasonableness. And as Glenn says, you need to just demonstrate that you've done what you can. So the likelihood that they contracted it whilst at work is low.
So testing, for example, could be another thing. So one of the things that we've heard people doing are requiring people to take tests. So, obviously, if somebody gets COVID-19 under the new track and trace system, they should be informing people who they've been in close proximity to as well. So taking action in respect of that, making sure that your staff adhere to that, again, will be another good thing to do. One of the other questions that we've been asked is in relation to people coming back to the office, and whilst it's unproblematic in the office itself, the travel on the way in and out of the office may be at overcrowded times. And the question that's been asked is whether, if we offer them an N95 respirator mask, I've no idea what that is, but I'm assuming it's something a bit more than your standard one that can be made out of a bra or something like that. Just for their commute, can we charge them for it just to cover the cost and no profit? Well, you can't charge for PPE that's used at work. Whether you can charge for it to come into work or not, I don't honestly know. I suspect you possibly could if it's to make their journey safer. I suppose the danger with that, in my view, is does it not rather imply that you recognise that you could be placing your staff in serious and imminent danger by asking them to come into work by the method that they are? And therefore, is it actually safe for them to travel at all? So I do think you need to be a bit careful on that. But you could, I suppose, offer employees the ability to take up one of those at the covering cost scenario, rather than make a profit and let them make up their own minds.
I think the other thing is as well, just to think about from a PR perspective, so not legal, but of the message that people may take from that, and whether you are concerned about their health and safety. So I think if you are going to do that, I think you would really need to explain the financial reasons of why you're having to do that as well. And it depends on the size of your organisation and profits and so on.
Okay, and then I'm going to take one more question from Karen. Karen, we miss your smiling face in our usual seminars, but the question that's been asked is, can accrued holiday pay be paid at 100% and claimed back through furlough in a redundancy situation? So holiday pay to an individual whilst on furlough needs to be paid at the 100% rate. Okay, in terms of a redundancy situation, you would not be able to claim in any event the accrued holiday payment in the same way as you can't recover the redundancy payment. But what you could do is you could effectively place people on holiday either by exercising the right under your contract or by using the notice provisions in the work and time regulations for somebody to reduce that holiday accrual during the notice period. And if that notice period is done whilst on furlough, at least recover a part of it through the furlough scheme, but you won't be able to recover 100% of it at all. Right, I'm going to wrap that up there because I'm conscious of people's time and other commitments. So thank you very much for attending the seminar. Can I just remind you of the feedback form that will be that is available to complete now and will also be emailed out to people. We're sorry we can't see people's smiling faces, but we hope you found this useful, and we wish you all a really good day. Just to flag up, we've also got a coronavirus hub that you may wish to take advantage of, with plenty of information on there. And if you want to connect with us on LinkedIn or send us a question direct, then we will endeavour to answer it. And we put a lot of information on LinkedIn in terms of updates. So if you send either myself or Padma a request, and we will be happy to connect with you in that regard. And also, if you've got any feedbacks, questions, or webinar topic suggestions in this brave new world, then if you could just drop an email to the email address on the slide there, events@irwinmitchell.com, then we'd love to put on events that are most applicable to you, rather than what we think you might want to hear about, and we'll endeavour to put something on in that regard. So thanks from me. Padma, thanks to Padma as well.
So, no, thank you. I didn't know whether you could hear it. So yes, no, thank you, as Glenn says, and just to reiterate that, and also to reiterate a thank you to We Are Adam for partnering with us today. So thank you.
Thanks, guys.